Welcome to Chapter 7, and in this chapter we're going to talk about capacity to contract. What do we mean by capacity to contract? Well, there are certain classes of individuals who may not necessarily have the ability, for one reason or another, to enter into a contract. So we're going to talk about who those individuals are and what would cause somebody to lack capacity to contract. We'll talk about what disaffirmance means and what can be done if a minor makes a contract and wants that contract to be upheld. And then we would discuss reasons other than age that might impair a person's ability to contract. So, as I said, for an agreement to be enforceable, all parties must have contractual capacity. There's a presumption in the law that anyone who enters into a contract does have contractual capacity. Incapacity can be based on age, physical condition, or public policy, which we'll talk about toward the end of this. And the burden to prove incapacity lies with the person who says, hey, I didn't have capacity to enter into this contract. And I've actually litigated this issue for people. In particular, it was a used car situation where these folks kept getting taken advantage of, and it should have been readily apparent to the car lot that these people lacked the capacity to contract. But they really stuck it to these older folks, and it was really unfortunate, and it ended up costing them money. Not my clients, the unscrupulous car dealer who thought they could make a quick buck off of people who obviously didn't know better. And it really was more than just not knowing better. These were people who really just didn't understand the basics of what they were signing. So going to the other end of the age spectrum, to minors, who is a minor? Well, in some states, they talk about people under 21, but generally minors are anyone under 18 years of age. And if one contracts with a minor, it's voidable, but only at the minor's choosing. So if an adult enters into a contract with a minor, an adult can't say, hey, heck, this contract should be void because he's a minor. The adult doesn't get that right. So the adult can be bound by it, even though the minor has the ability to say, I don't want to do this at any point. Now, what happens when we've got two minors? Well, in this case, either minor could choose to void the contract. What types of contracts can a minor make that can't be avoided? Contracts of minors for what's called necessaries, excuse me. Um, and what that means is food, clothing, shelter, things like that. Um, if a minor were to contract for those things, and not from a parent or somebody who's legally obligated to provide those, and we'll come into that a little bit later, but uh, if a minor contracts again for food, clothing, shelter, things like that, the minor, in fact, can be held liable for those things. Um, and there's a case I think that your book talks about where a minor required life-saving medical care, and the parent didn't have insurance and couldn't pay the bill, and the hospital, in fact, sued the minor for the value of the surgery, which is a very unfortunate situation. In certain states, minors can be held liable for business contracts and also for their educational loans. So if you think about the 17-year-old that goes off to college in their freshman year, can they sign a contract for their student loans? Certainly depends on what state they happen to be in. Then we get to disaffirmance. What is that? That's when a minor says, I don't want any part of this contract. Um, they can do this at any time while they are still minors, and there's a brief window of time once they've reached their legal, the age of majority, that they can still disaffirm a contract. But if they got something for value, they still have to return the item if, of course, they still have it. Ratification means basically that the minor says, you know what? I know I made this contract while I was 17 or 16 or whatever, and now I'm an adult. I'm going to go ahead and honor that contract. But they can't pick and choose which parts of the contract they want to honor. It's an all or none proposition. So the mere fact that someone makes a contract as a minor doesn't necessarily cause that to be a void contract. It's just voidable. And a minor can again choose to ratify that contract, but only once they reach the age of majority. And then if they do ratify that contract, then it's a completely valid contract going forward. So if you want to make a contract with minors, which is generally not a good idea, how do you protect yourself? You can require that an adult, a parent or guardian preferably, co-sign for the minor, because then you at least have the right to sue the co-signer. Even if the minor may void the contract, the parent or guardian that co-signed is still going to be on the hook. So you at least have some protections in terms of that. Stepping away from the contract arena into the tort arena where minors can cause damage to things. This is where contract law and tort law are separate in that the minor can be fully liable for any torts acts just as if they're an adult. So if a minor goes in and vandalizes a school, for example, they can't say, hey, I'm a minor, I'm not responsible. Um, that is not the case, and yes, in fact, they are responsible. What if a minor misrepresents their age and enters into a contract and says, I was really 18, or I'm 18, but I was really 17, therefore you can't hold me accountable under the terms of this contract? That may be a situation where the court imposes a quasi contract and the minor may still be held liable if they made that misrepresentation. Oops, somehow I got ahead of myself here. Okay, mentally incompetent. People can be incompetent as a result of mental disease or defect, as they say under the law. And this can be somebody who, as your slide indicates, suffered a stroke, has dementia, is lacks capacity due to low IQ. Um, and if you were to make a contract with somebody that is under guardianship as a result of this mental disease or defect, those contracts are void. And if you discover later that you've entered into a contract with somebody who is under guardianship, um, all they have to do to prove that they were incapacitated is show the order from the probate court indicating that, and it will completely unwind that contract. So the best course of action is if you're really concerned that you may be entering into a contract with somebody who is not competent, suggest that they consult with legal counsel. And if they have an attorney involved who's going to be advising them, then you can have at least some assurance that somebody's looking over this and looking out for this individual's best interest. And certainly, if the attorney feels as though this person doesn't have the capacity to contract, they will advise them not to enter into a contract. So if somebody has not been declared incompetent by the court, we treat those contracts the same way we would as with the situation where they are minors, where they are voidable. So the incompetent person can choose to void the contract, or they could certainly choose to honor it, and that's fine. And again, the difference between whether somebody is declared incompetent or not declared incompetent is whether or not the contract is void, which is the case where somebody has been declared incompetent, or voidable, where they haven't. and the contract may survive if the incompetent person chooses to perform under the contract. The key thing is that somebody must understand that they're making the contract at the time that they're doing it. If somebody is so disconnected from what's going on around them that they don't even have that basic understanding, um, this is going to be certainly a contract easily voided in court. Then we get to intoxicated people. Um, Contracts made with intoxicated people are voidable. Somebody who gets drunk in a bar and bets the house that, I don't know, whatever kind of bet somebody might make drunk in a bar, those are voidable. And when the person sobers up, they can say, I was drunk and I'm not paying off on this ill advised situation I entered into. And they are permitted to do that. Or they can say, yep, I'm going to be held accountable for what I said, drunk or not. And yeah, if I told you I was going to sell you my boat for $10, then that's what I'm going to do. But they have the ability, once sober, that's the important thing, they must be sober, to either affirm or disaffirm that contract. Um, in some states, people who are legally declared habitual drunkards cannot make contracts. We don't have such a statute. I'm not clear what states do, but apparently there are some. Uh, and those would also apply to habitual drug addicts as well. Again, not something that in Vermont or New Hampshire, we don't have um, provisions to declare somebody uh, a habitual drunkard. Um, People who are incarcerated may have limited abilities to enter into contracts until they're out on parole. Um, and part of this, and so it depends on which state you're in. This is another state specific thing, but be really careful entering into any sort of a contract with somebody who is incarcerated because that contract may be voidable. And that concludes our chapter on capacity to contract.